Hi, this is Chapter 13, Interrogatories and Requests for Production. Define interrogatories and requests for production of documents and things and understand the best use of each. Interrogatories and requests for production occur early in the discovery phase of the litigation process. Of course they do. They're often submitted to the opposition at the same time, and questions and requests often form the basis for other forms of discovery. So you're just basically, looking for evidence, and even if that evidence is not going to be something you use in court, it might lead you to where you can find some other evidence that you do use. Okay, so an interrogatory is a formal request for written answers to written questions. And the answers are made under oath and must be submitted within the interval required by the rules. So, a deposition is kind of live, but an interrogatory is still under oath, but it's much more manageable because you don't have to set up the video equipment, you don't have to travel, you don't have to have the lawyers all in a room together at the same time. It's just trying to get some information. Now, they can be objected to if a privilege exists. It's the same kind of privileges we discussed in e-discovery. And the answers must be signed by the attorney for the opposition. Production of documents. It's called documents, but it's not just documents. They include tangible things, electronic documents, and entry upon the land of another. It includes movable and non-movable items. So a movable item is something that you can pick up and carry around. A non-movable item is something that is either real estate or attached to real estate and cannot easily be removed. So even though you couldn't pick up a car is movable. Same with some heavy piece of machinery, that's a movable. Interrogatories and requests for production. Requests for production. Answers to requests must be submitted with the interval required by the rules. And the answer indicates whether inspection is permitted or not. Request for inspection may be made on non-parties to the suit. Now, you have a certain time frame that you have to produce everything for the other side if they've asked for it. It's usually about 30 days. Discuss the discovery time frame and how it may be modified. Okay, discovery may occur without permission of the court as long as the trial is not delayed. And deadlines may be extended informally between the parties or remission to the court for good cause. So you just might need to call up the opposing side and say, hey, we're real busy, how about next week instead of this week, even though that'll extend the deadline. Draft questions and answers for interrogatories. Initial disclosure. Most jurisdictions limit the number of interrogatories. In Louisiana, it's 35, which is high because a lot of places it's 25. In federal court, if it's going to be in the federal courts, it's 25. Parties are also required to make certain additional information available through the mandatory disclosure process. Drafting questions. What to ask and how to ask it is a process that includes analysis of underlying claims, needed evidentiary proof, and strategy. So 35 might sound like a lot, but really you can blow through those real quickly. So you want to make sure that you are asking relevant questions and trying to figure out not just what you want to ask, but how you in your strategy will develop based on those answers. Drafting question. Identify claims, defenses, and issues from the pleading. Analyze information already disclosed to ensure satisfaction of elements of claim and evidentiary requirements. And decide which questions to include in the interrogatory. Now, they must be served on the other party. You don't need to get the court involved, but you do have to serve them. And In preparing responses follows process similar to creating interrogatories. We want to be, open and candid to a point, but you want to start objecting if they're asking for privileged information, trade secret, or it becomes overly burdensome to get the answers to them. Usually you have about 15 days in Louisiana to object to the interrogatory. Otherwise, you have to answer it within 30. So objections to questions could be privileged communication, could be work product, trade secrets, duplicative materials, or vague or overly broad or burdensome. So that's where you really get a lot of the questions thrown out. It's just like, hey, I don't really know what they want here. It's a very broad question. It could lead to requiring me to give out trade secrets, or it's just burdensome. And so then when you object, and I said you have 15 days in Louisiana to object, you ask the court to determine whether certain information must be disclosed in discovery. Now, the lawyer should be there with the client to answer interrogatories. Try to note discrepancies with their answers and reconcile them. You don't want to give them, if you are unsure, if you're giving conflicting answers to different questions, you got a problem. And sometimes this may change the entire outcome of the client's case or your strategy in dealing with it. The lawyer should make sure that they are fully answered, identify objections, and may reveal new areas of discovery, and may reveal new theories of the case. Prepare requests and responses for requests for production. Now, this is designed to obtain all tangible material, tangible, touchable, regardless of how they were created or stored. Forces the legal team to obtain original documents from the client. Now, those could be, electronic documents, but they're still considered tangible. Forces the legal team to read and evaluate contents of documents and organize them. Now, there's some documents you're just going to need, even if it's not the other side that has them. It could be, the police report, or the hospital bill. It's preparing a request for documents is almost identical to preparing questions for interrogatories. You review pleadings and you review the answers to interrogatories. And responding is very similar to interrogatories. Review these requests for relevance. If it's not relevant, you can object to it and say this is not something that we should have to produce. It's not about what they're asking for. It goes way beyond what this case is about. So that's when you would say this would be irrelevant. Reviewing responses to requests for production can be tedious. You have to review possibly large volume. You know how much paperwork or email gets generated in one day. Imagine being requested for 2 weeks' work. Follow through on all objections, and a motion to compel may be necessary if the other side is not producing what has been requested and is a valid request. Okay, that wraps up this presentation. I have two really good videos from YouTube. I would recommend watching both, and they will really help you. I'll also post some stuff about Louisiana rules regarding this.